In the bankruptcy world, most people believe it's a good thing if trustees or debtors in possession can sell avoidance actions, and that's exactly what the Fifth Circuit held. The appeals court sitting in New Orleans ruled that a trustee can sell an avoidance action, which means a preference or a fraudulent transfer suit. The opinion is not altogether beneficial for debtors for reasons I will explain in just a minute. The Fifth Circuit had two reasons for authorizing the sale of avoidance actions. One of those was Section 541A7 of the Bankruptcy Code, which says that estate property includes property acquired after filing. Well, that's all fine and good. And if I had it my way, I would have wished that the Fifth Circuit had made that the only basis for its decision. However, the Fifth Circuit also ruled that an avoidance action is estate property under Section 541A1. That section says that estate property includes all property of the debtor as of the date of filing. Well, of course, as you know, avoidance actions really don't seem to exist until after filing, because that's when they're created. But the Fifth Circuit went on to say that an avoidance action is some kind of a, let's call it, inchoate or contingent property interest that exists before filing. Well, that certainly means, of course, that debtors have the right to sell avoidance actions, but here's the hooker. I think what's going to happen as a result of decisions like this is that secured lenders, banks, and everybody else are going to take security interests before bankruptcy in general intangibles and probably say specifically that that security interest includes avoidance actions if there is a later bankruptcy. Well, what that's going to mean is that what the Fifth Circuit has given on one hand, it has taken away on the other, because we're going to have secured creditors getting enforceable liens on avoidance actions. However, I do not believe that is the inevitable result. And here's why. The Bankruptcy Code isn't the only or final authority on what is an enforceable pre-petition security interest. We also have to look to the Uniform Commercial Code. And as we all know, to have a valid enforceable security interest, there must be attachment before bankruptcy. And for me, the question is this. If we're talking about some kind of an amorphous contingent asset, does that asset attach to a lien before bankruptcy? I suspect that there are going to be some courts which believe that this kind of an amorphous contingent inchoate asset does not have sufficient existence to support attachment in the UCC sense. Well, I know as a matter of fact that there is at least one major lawsuit pending right now raising precisely that question, and perhaps one of these days we will be reporting that decision in Rochelle's Daily Wire video edition. And that's who I am. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. The good Lord willing and the creek don't rise, I'll come back same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and a very good day.